Good morning, everyone, or good afternoon or good evening, depending on where you are joining us from. I am Shazad Charania. I am the Acting Director General at the Attorney General's Office. And welcome to the event entitled Reviewing the Review, What Needs to Change at the International Criminal Court, where we're going to be examining the detail of the independent expert review of the International Criminal Court. So first of all, how did we get here? Well, on the 24th of April 2019, in an op-ed entitled The Court Needs Fixing, 4 former presidents of the Assembly of States Parties wrote as follows. They said, as strong supporters of the International Criminal Court, we believe that an independent assessment of the court's functioning by a small group of international experts is badly needed. They said that while we have never needed the court more than today, the powerful impact of the court's central message is too often not matched by its performance as a judicial institution. And they went on, we are disappointed by the quality of some of its judicial proceedings, frustrated by some of the results, and exasperated by the management deficiencies that prevent the court from living up to its full potential. That is why we think an independent assessment of the court's functioning is needed. Now, 2 weeks later, on the 10th of May, 2019, the ICC President, Judge Chili Abuya-Soji, writing on behalf of the principals of the court, called for a comprehensive external review of the court's overall performance and capabilities. And then at the end of the year, at the Assembly of States Parties, the member states of the ICC unanimously adopted a resolution which commissioned a review to make concrete, achievable, and actionable recommendations aimed at enhancing the performance, efficiency, and effectiveness of the court and the Rome Statute system. Now, the review was mandated to focus on 3 areas, and those 3 were governance, judiciary, and investigations and prosecutions. And then on the 30th of September this year, the experts issued their report, and it consists of 348 pages and 384 recommendations. So today, in the first public event, as far as I know, since the report issued, we will assess and analyze the substance of the recommendations. And to do that, I have as distinguished a panel as you could hope to assemble. My first panelist is Sylvia Fernandez, former judge at the ICC between 2009 and 2018, president of the court between 2015 and 2018, and also chef de cabinet for a number of years to the first prosecutor. Sylvia Fernandez played a key role at the Rome Conference as part of the Argentinian delegation and chair of the working group on the rules of procedure and evidence. Second, we have Dr. Douglas Gilfoyle, Associate Professor of International and Security Law at the University of New South Wales, Canberra. He has taught international criminal law for 13 years and has published extensively in recent years on the ICC, including both on its legal output as well as its organizational culture, most notably in the Melbourne Journal of International Law, but also on the blog of the European Journal of International Law. Next, Professor Lis Van Sliedrecht, Professor at Leeds University Law School and Chair in International and Comparative Criminal Justice, widely published. Lis Van Sliedrecht has written books on pluralism in international criminal law and individual criminal responsibility in international law, as well as spending 3 months at the International Criminal Court in chambers as a visiting professional. And last but not least, Angela Mudukuti, international criminal justice lawyer working with the Open Society Justice Initiative. Angela has consulted with Human Rights Watch and the Wyoming Foundation and worked with the Southern Africa Litigation Center on seminal cases, including relating to the arrest of former President Bashir of Sudan. And Angela has also worked for the Office of the Prosecutor at the ICC and published extensively. That is our panel. So over the next 90 minutes or so, we are going to have a discussion on 5 elements of the independent expert review. First, governance, then culture, then the Office of the Prosecutor, the Judiciary, and finally, relations with the Assembly of States Parties. Now, I've asked the panelists to keep their interventions short and snappy so that we can get through as much as possible. For our audience, please do submit any questions you have into the Q&A box, and I will try to do two things at once and pick them up as I go along within each segment, and hopefully we'll have some time at the end too to pick up any questions then too. So let's get to it. Let's begin with governance. Now, the report talks of the contradiction between the ICC as, on the one hand, an independent judicial institution, and on the other, an international organization, which the report says has led to tensions between the court as an adjudicative mechanism and the ASP as its governance arm. And it suggests a three-layered governance model as a way to navigate this. So the first two layers encompass the ICC as a court, with the first layer being the judicial and prosecutorial activity, and the second layer, the administration of justice. And then the third layer acknowledges the ICC as an international organization, and so addresses the administration of the court as such. Sylvia Fernandez, if I can turn to you first for your reflections on this governance model.
Good morning to you all. It's a real pleasure to be part of this event, to this first public event on this report, which is a great opportunity, but also something that I think we need to all approach with certain care and caution, because there has not been yet a possibility or opportunity for a dialogue between the ASP and the court and all others that are involved in this process. I have to say, first of all, that I find this report quite impressive, with an impressive pool of recommendations. So really there is a great opportunity to take good advice from there. Now, on your specific question, I would say that this, I think it is a very interesting and useful analytical framework to expose this tension between the court, as a judicial entity, and an international organization. And I think, and these three layers of responsibilities is also quite a useful tool to try to understand all the things that this system, because, and also the experts, they do say this, it's not just a court, it's a system, all the responsibilities that they need to undertake. At the same time, I think we have to remember that two natures or a dual nature doesn't mean that the court has a split personality. There is no split personality there. I think we need to always remember that the court, yes, it is an international organization of a very special nature because it is a judicial entity. That is the raison d'etre of the court. So anything that it is done in order to reform it needs to make sure that it advances this nature of the court as a court. So that means we need to preserve always its independence in all layers, because of course there are different layers, and I think that is a useful analytical framework, as I said. But at the same time, all these layers are connected, even with the one that is purely administrative, because that also has an impact on the court as a judicial entity. So I think it is good to look into these three layers, but we always have to remember that there is ultimately one raison d'etre, one essence, which is judicial independence and prosecutorial independence, and that all layers, while it is interesting to divide them and look at them differently, they are all very much interconnected. Thank you.
Thank you, Judge. Professor Lis Van Sliedrecht, your views.
Hello from North Yorkshire. Thank you, Shazad, for organising this, for chairing this, and thank you, Bikkel, for putting up this platform. So I would like to build on the comments made by Sylvia, and I agree with the analysis that, of course, they are connected. And while it's good to signal the tension between the two functions, I think it's also good to bear in mind that, of course, one influences the other. And what I think this requires is that the person in a leadership position has to have a firm grip of this organization. I think that's really what the report to me signals. There has to be this firm grip at the top in terms of management and good governance, and not just for the whole organization, but also for the different organs. Running the ICC as a professional organization is beneficial, not just to making it a good working place or a good working environment, but also its judicial function. And I think it insulates the court against critique or pressure on the judicial and prosecutorial function. So one of the things I really found interesting in the report is that they recommend that recruitment processes for managers focus more on managerial and leadership skills throughout the organization. And there is a recently established leadership framework project within the ICC, I understand, and the report also notes that. And that's really good that there is that awareness. But, you know, we're 18 years on from 2002. So it was also, to me, a bit surprising. And added to the surprise was the bit in the report on the confusion, or rather delay, of setting clear key performance indicators, so key KPIs. Apparently there's been work on that. It's a big project. The ASP's sat down with the court to try and you know, work those out, but there's no, as I understand, no agreement on those. And that's really unfortunate. And yes, it is difficult. You know, I think every senior judge leading a judicial organization, whether it's domestic or international, will have to deal with that tension, but will also have to meet KPIs. So I think there's a lot of shared experience that the ICC could also work with in that sense. So they're not, you know, unique in that respect. And one example to show that it's important to have this in place and to be able to explain what you are doing and to have a framework that measures effectiveness and efficiency. An example of, if you don't have that, how that affects you is, I think, the UK statement in the ASP in 2018, which to me was a rather unfortunate statement, because, well, there was critique basically on the ICC looking into alleged war crimes allegations in Afghanistan. But what they said in justifying this critique was, well, you know, the court is really not running smoothly. It's not performing in terms of the KPIs and closing its investigation. So there was a lot of talk of how it was managed, in fact, and that clearly erodes trust on the part of the state party. So I think the ICC would really do a good job in getting its house in order, in organising itself, managerially, good governance, all of those things, to insulate itself from such critique. So that's where you see actually the connection between the two.
Thank you, Professor. Dr. Douglas Gilfoyle, your views.
Right, so look, I'm going to disagree slightly with what's already been said. If you have independence without accountability, and maybe this is a nuance on Lis's point, if you have independence without accountability, you're going to get one of two things: dysfunction or lack of direction. And the court has had too much of both. So we keep talking about the first priority of the court must be judicial and prosecutorial independence. I think that's misguided. The function of a court is not to be independent. It is to perform a judicial function impartially. And impartiality, being unimpeachable in the delivery of justice, is supported by two things: independence on the one hand and accountability on the other. Now, what a lot of supporters of the court, in a very well-meaning way, tend to emphasize is the impartiality and view any accountability as a subtraction from that impartiality. But actually, if we simply have a collection of judges each going their own way, prosecutors without a uniting strategy, then that's a problem as well. So we shouldn't shy away from the fact that the Assembly of State Parties is, in the statute, and in the independent expert review report, the legitimate management, supervisory and oversight mechanism for the court as a whole. Now, saying that can sound a little bit radical, but it goes also to what is our conception of the court. So it's terrific that the report acknowledges the court is also an international organization, and then it introduces complexity. And it's perfectly right to say the court is a unique international organization. But at one level, that isn't saying very much. Every international organization is unique, right? The Universal Postal Union is not the International Maritime Organization, is not the United Nations, is not the International Criminal Court. So the question is how we make the organization work. And one of the things that's baked into the statute, really, in a sense, is two competing visions of the court. Is the first job of the court as a classic international organization, a bargain amongst its members? Is it, as it were, a kind of supra or mega regional organization that exists as a pact amongst its members that they've all made certain common commitments to the prosecution of international crimes, and the court exists to hold members to that bargain? Or is it an instrument of universal justice that is hampered by the fact that a handful of recalcitrant states and major powers, well, a third of the states presently existing, have not yet joined it? And which of those visions you prioritize informs everything else? And I'll have more to say, I think, about those themes later, but I think as a sort of opening position, that's more than enough from me.
Thank you very much. Angela Mudakuti, over to you.
Thank you for having me. Thank you to the organizers. I'll just begin by saying that I too think the experts did a very good job under very extreme circumstances with a limited amount of time and also the restrictions brought by the COVID pandemic. So I think they were frank and forthright in their assessment and did really produce some actionable and useful recommendations. I particularly like that the report does begin with governance, and I'm going to disagree slightly with Douglas on this, but I think that the experts did a good job in separating the ICC as an international organization, as a judicial institution, and clearing the lines of reporting with that. And I think the governance issues have really been at the heart of many of the issues the court has faced in the past. And so clearly establishing who's responsible for what and what the lines of authority are, I think is crucial to the court's functioning going forward. And I do have to say that I think the preservation of judicial and prosecutorial independence is paramount. And I think this very well thought out structural governance proposed by the experts makes a lot of sense, because I think judicial independence and impartiality and independence from the Assembly of States Parties in that respect is crucial to the credibility of the court and the cases that it will bring or will deal with. But this is not to say that states parties don't have an important role. Absolutely they do, especially in terms of the election of officials and the provision of funds. This important role gives them a certain degree of power, but also a great responsibility to act in the best interests of the court. And this is something I'll get to talk a little bit more about later, but just in terms of the election of qualified officials who are of high moral character and qualified to lead the court. This is something that the states parties have to do, and something that they have to take seriously, but again, with the best interests of the court at heart and not their own political agenda, because as we know, judicial and prosecutorial elections in the past have been highly politicized instead of being a merit-based process. So I think acknowledging that states parties have a role, a very important role to play, and that it is specific to these two things is very important. And I think the experts make that very, very clear. And the development of the three-layered governance model that you described, Shehzad, I think is very, very important, because again, it separates who's responsible for what, but it also does not negate the one court principle, which I think is something that is also important to the functioning of the court. And in the governance section, they make it very clear that this one court principle does fall into layer 3, which is the administration of the international organization. And these, I think, are distinctions that are very important to make, and the experts have made them clear. And going forward, I think they'll be useful in terms of how the court functions. And what I particularly like about the governance section is that they didn't just invent something out of nothing. There's precedent from other organizations, but there's also solid legislative backing from the Rome Statute. And they mention the articles that support their understanding of the organization and how it should function. So Article 38.3, for example, 43.1, and Article 119. And I think it's very important that whatever is done based on the Rome Statute. And I think the experts got that right as well. Interestingly enough, also with the governance section, is there's a definite move to empower the registrar, which I think is new, and I think I'm very interested to see how this plays out, because I think it could help with some of the internal issues that the ICC has had. And I will finish on this last point. I think the most important and fundamental part of the governance chapter is that it sets the tone for the rest of the report, because already they highlight the values and the principles that are important. One that I've already mentioned, the preservation of judicial and prosecutorial independence without absolving the ASP of its responsibilities to provide oversight. Another one that you get from that section is efficiency and effectiveness, accountability, which I think is extensively dealt with throughout the report. So it's not just that the prosecutor and the judges get to do what they want. There are structures that have been put in place or suggested that will keep them accountable. Gender equality, also something you get that is mentioned in the governance section. Inclusion and also the well-being of staff. So all of these principles are very clear from the beginning, and they set the tone for the rest of the report to come. And they also set a foundation upon which the experts build as the report develops. Thank you.
Great, thank you, Angela. And it's good to have some disagreement on this at the very start. At the heart of this, I think, seems to be this tension between, on the one hand, an impartial court, and on the other hand, a governance body that is made up of 123 states, which are political and have their own agendas, and how that can be squared off for the good of the court. But I'd like to move on to the question of culture, because it's arguably here where the report is most stark and confronting. And the report talks about the court appearing to suffer internally from distrust interorgan, as well as between staff and higher and senior management. It talks about a culture of fear, talks about us and them with respect to organs, the inadequate style of management, the absence of leadership, two themes that Lis and Angela have touched on, and the absence of those causing stress, extended sick leave, including for burnout, self-perceived aristocracy, that's a quote, amongst the judges, treating staff as commoners, bullying and harassment, low morale. One of the most stark sentences was that the working environment at headquarters in The Hague too often does not live up to the spectacular office accommodation provided. Angela, maybe we can start with you, as you touched on some of the issues around bullying and harassment, and you could pick that up and expand. Thank you.
Thank you. This bullying and harassment is a very important topic, and a topic I feel very strongly about. And I'm very glad to see that the experts tackled this issue, because it is clearly pervasive at the International Criminal Court and at other international organizations. And this is, quite frankly, unacceptable. But I'd like to begin also by thanking the members of staff who came forward with their stories, because that's not an easy thing to do. And it's so important to do because it helps us understand the extent of the problem and also then helps us address the issue. You can see that the experts clearly listened to staff members and took a detailed look at the factors that contribute to bullying and harassment and made recommendations as to how it can be addressed. So this is something I think is very well done in the report. Before I move forward, I'd like to bring everybody's attention to the latest report from the Independent Oversight Mechanism. This is the 2020 report, and there is an incident of sexual harassment that's detailed in that report. It was an intern in the Office of the Prosecutor, and the perpetrator was a staff member of the Office of the Prosecutor. And the IOM found that the staff member's conduct constituted unwelcome, and I quote, sexual advances that interfered with the intern's work and reasonably created an intimidating, degrading, hostile, humiliating, or offensive work environment. They also found that there was no room for any reasonable doubt that this indeed did take place. But the sanction was written censure against the staff member. Now, from where I sit, the sanction and the offense, there is no correlation there. And I think this is indicative of the problem at the ICC, and also something that the experts highlighted, that the current mechanisms are inadequate when it comes to dealing with complaints of bullying and sexual harassment. But of course, dealing with the complaint is much further down the line. The experts also talk about measures and steps that come before dealing with the complaint. One of the issues they raise is that we need more women in management roles. I couldn't agree with this more. If you look at the 2018 ASP report from the Bureau on Equitable Geographical Representation and Gender Balance, they point out that 1 out of 9 staff members at D1 level is female. 13 out of 43 at P5 level are female. 30 out of 83 at P4 level are female. And lastly, 79 out of 172 at P3 level are female. There is clearly a problem here. In addition to that, they note that, and I quote, the adversarial and implicitly discriminatory environment that exists against women. They mention the challenges that female interns face, that female members of staff face in relation to their male supervisors and sometimes their male peers. And most importantly, in my view, they highlight that it is essential to lead by example. Having leaders who are of high moral character, who do not tolerate this kind of behavior, who do not engage in this behavior, and who also effectively address it when it's brought to their attention. This is so important, and I could not stress this enough, given that it is an election year this year. And a lot of organizations, civil society organizations, have been very strong on the question of vetting to prevent exactly this kind of conduct, to make sure we have leaders who are above reproach and of high moral character. The experts also talk about the importance of training so that managers understand the consequences of bullying, and the importance of having avenues for staff members to report an issue and to lodge a complaint and get the necessary support. And these are all good general guidances, but they also then provide more concrete solutions, for example, calling for the effective implementation of the existing whistleblowing policy, which is supposed to guarantee safe and confidential disclosure. So all of this is just to say that there is a problem, a very, very deep problem at the ICC, and that the experts have really done a lot to bring it to light and to provide actionable recommendations. And I sincerely hope that these will be taken on board, because we cannot continue the way we're going.
Thank you, Angela. Douglas, please pick that up, but also I wanted to raise another point with you, which is that the report talks of members of staff who are unhappy and dissatisfied, yet at the same time, the report says that few staff choose to leave the court, with a surprisingly high percentage of staff, the report says, having been with the court for over a decade. And the report concludes that the combination of a relatively high level of dissatisfaction with a workforce not being sufficiently rejuvenated through staff turnover means a suboptimal working environment that's far from optimal in terms of performance and staff welfare. And as a result of all that, the experts propose a policy of tenure for staff of grade P5 and above. I wondered what your thoughts on that point were, what your thoughts on that point were, in addition to the broader question of bullying and harassment. Thank you.
Yes, well, look, I'd agree with absolutely everything Angela has said, and on those direct and concrete instances of bullying and sexual harassment. I don't think there's much I can add in terms of the broader cultural environment that supports those outcomes, where there is bullying and harassment, and where the action that's taken is manifestly insufficient. Then I think a number of the points you've made, Shazad, go directly to that. And the report does talk of an organisation where a lot of staff are deeply unhappy but don't leave. And part of that is simply that comparable work to what they're doing in an organisation where they believe in the mission may not be available elsewhere. There's also mention in the report and some of the surrounding discussion of, as it were, the phenomenon of golden handcuffs. You know, if you're doing work that's highly valued and in some cases very well paid, you're not necessarily going to get rewarded for that experience when you return to a national system that prioritizes, particularly in the field of criminal law, obviously national engagement with the local system and a depth of experience. So people may feel that they have relatively few other options. The report does also, though, speak to the fact that when you have people who are there for longer than a decade in those senior roles, then actually, in a sense, those are the people who set the leadership tone for the organisation. If permanent international civil servants, as it were, know they will be here beyond the life of this particular prosecutor or this particular crop of judges, that gives them far more influence on the culture of an organisation than their ostensible position might suggest. And the report is very frank about the fact that it is simply not healthy for any major organisation to have such very limited mobility, and that the culture would be enhanced, and there would be questions of sort of dynamism, managerial experience, new approaches that would come with having a policy of tenure in the senior roles. And they do suggest that sort of 5 to 9 year window as being optimal. They note that in the short term, that can't really be implemented in a procedurally fair way, other than encouraging present incumbents perhaps to take early retirement and making sure that any such new posts are time limited. The thing I find peculiar about the report is they note the extraordinary dissatisfaction, or well, I may be overstating it, but very high levels of dissatisfaction amongst the legal officers in chambers, for example, who have little or no career prospects beyond the P3 level, perhaps one step higher if referendars are implemented, as the report suggests. But they don't suggest tenure. What they suggest there is more lateral career mobility, going out to other international organizations or spending time perhaps at field offices and so on. All of that's to the good, but I do wonder whether the tenure principle should actually apply through the entire organization, and also whether the organization would benefit, as they ultimately recommend, from more secondees in from member state governments. Now, there's a question of resource disparity there and whether that would overly privilege highly resourced member states, but there would have to be ways that that could be perhaps better thought through. And indeed, if the more junior posts rotated more regularly as well, there'll be more opportunity perhaps to recruit people for a period of 5 years from what would otherwise be a government post at the national level to the court. And also, I think that would address cultural issues perhaps between the court and the ASP. If there was more exchange between member state governments and the court, I think that could build a good deal of confidence and experience on both sides. But I'll leave my comments there.
Thank you, Douglas. Elise.
Yeah, so I agree with most of what's said, so I'll keep it brief. Interesting indeed, Angela, raising the braveness of people coming forward. And this is something you see, of course, in sexual harassment cases throughout the profession. The legal profession is endemic when it comes to sexual harassment, unfortunately. There was a report in May, I think, by the IBA, the biggest report on bullying and sexual harassment in the legal profession, where 1 in 3 females reported having been bullied or harassed. And almost 60% of the people said that they'd not reported the cases, so very brave for those who did come forward. Now I think research shows there's a clear link between sexual harassment, bullying, and insufficient diversity. So also there, I agree with what was said. It's clear, the report makes it very clear, this should be done better. There should be more women in senior positions throughout the organisation. Yes, we have a female prosecutor, we had a female president, but unfortunately that did not trickle down through the whole organisation, and it would do the organisation much good if it would provide for it. And I think it's also indicative, and again, the research backs this up, the broader workplace situation is unhealthy. When these things happen, that says something about the work environment. And there I also agree with what Doug said about a more professional approach towards the people working in these positions where they've been in it for a long time. It's not good for an organisation, but they've got no prospect. And to me, it seems there is at the moment no coherent and professional system of performance appraisal, something else the report picks up. And it would be really good, I think, if the court would invest in staff support and staff development, a system of promotion, where you actually not just have a performance appraisal to see if a person was doing the job well, but also, towards promotion, supporting that person for the next step up. And there should be some perspective of indeed moving to another position, whether indeed in another international organisation. And yeah, we have to enhance mobility within the organisation. It's been said by Doug. I think it's very clear, the report says it. One of the things, and this is just in the national legal system that I'm most familiar with in the Netherlands, is where we've got this group of legal officers that work with the judges, and they are expected, there's no rule around this, but they are expected to move on after 5-6 years around that time. And then they very often become a judge for a while and they return. as a Supreme Court judge. So because there's so much expertise there, but there needs to be, I think, a broadening of experience and also for their employability, as some of them, I think, are stuck in their positions. Yeah, so those are some reflections. Thank you.
Thank you, Elise. Over to you, Sylvia, and perhaps in your remarks you could pick up on some of the points that Douglas made on tenure, because as a judge of 9 years, you, of course, were part of a cadre of individuals that did have some tenure, that left after 9 years, and whether there might be some lessons and pitfalls in that system that might also apply to senior staff having tenure.
Thank you very much. Yeah, maybe I could go directly into this, which is related to also to low morale and difficult working environment in chambers. And actually in chambers, you have this situation where you have people that have been working there for a very long time, and then you start asking questions whether it would be better to have some kind of a tenure there. But then you have to think also that one of the problems also there is that every 3 years you change 1/6 of the bench, 1/3 of the bench. You change every 3 years 6 judges, and that brings a lot of changes to chambers, and it also makes it very difficult when you are trying to achieve more cohesion, more predictability, where you try to find a more stable culture. This every 3 years is disrupted by this huge change in chambers. So we need to think into this, because if you're going to also try to rotate more in terms of the staff, you may enhance this lack of stability, I would say, in chambers. I always said that at the court, you need a combination of stability and change in order to be able to consolidate the institution. So how to do it is not an easy job, and it's easier said than done. Now, of course, there are many recommendations there that would help, including, for instance, a longer induction for judges, so they socialize earlier into the system. But relating to the staff, indeed, some staff there have been very, very long time there. But I think also there are some recommendations in order to enhance to improve working methods, for instance, avoiding the assignment of individual persons to judges and go into more of a team type of culture. I think that would be extremely helpful. And actually, there is a lot of that already being done. The creation of these head of chambers is also something that could help. But the fact of having a tenure, you also have to think that one of the main reasons for discontent among staff is that it is a very horizontal structure with very little possibilities of promotion. So if you go into a tenure, for instance, for the high level positions, let's say P5s, which is the highest you have in chambers, we will need to look how that's impact on the rest. Because on one hand, it would open up new opportunities, but at the same time, you may also increase the discomfort because people would go for a long time into more junior positions, and then maybe even resistance to even go up or go higher, because then they would risk their jobs. So you don't want to have stagnation at P4s because they don't want to become P5s in order to have to leave the court in a number of years. I think really this issue of tenure, this needs to be looked into each organ and each type of positions to see how they would impact on the rest. But in order to improve the culture at this point, I think many of the other recommendations would help a lot. Performance appraisals have been mentioned here, and also who does the performance appraisals, because the system is there. The problem is who does the performance appraisals. You need to look into the responsibilities of the head of chambers. You need to move forward into this teamwork. And of course, you need to move forward into everything that goes into enhancing collegiality among judges. But also, I think that is part of other segments of the report. In terms of maybe if I say one little additional word, because I wanted to also mention the difficult tensions between organs, the interaction between the organs of the court. And here, again, is not an easy fix. And of course, the report has very good recommendations, but of course, they also recognize, and they say it many times, that it is a very complex institution because it's an ecosystem, it's a system. You have at the court, it's not only a court, you have their organs that in most national systems would not even sit together in the same building. They are completely different. The prosecution has nothing to do with the judges. And then you have the registry providing services to all, but also to the defense, also to victims. And the registrar is acting under the authority of the president, but the president has no authority over the prosecutor. And the registrar also provides services to the prosecutor. So it's a very difficult mix. And how this has been done in trying to fixing this issue. Well, what I did is to try to enhance consultations. Since no one really has all the powers over everybody else, you enhance the coordination council, you create working groups, inter-organ working groups for many issues, communications, outreach, you name them. So these were multiplied and they were working quite effectively, I would say. And the idea was to try to improve interactions and align visions of all organs. But that has a downside. And I think that has also been identified by the expert, is that by creating all these consultations, processes, and working groups, you run the risk of having very bureaucratic and slow decision-making. Here is, again, where we go into these three layers, that this and this recommendation of each organ trying to focus on their core business, I think that may also help to try to identify who takes the lead in certain functions in order to avoid that everything is done collectively, which is nice in terms of trying to be more collegial, but it does have a downside of slowing down very much the processes. So, but I think in the report, you have a number of very good recommendations trying to improve in all these perspectives. Thank you.
Thank you, Sylvia. I mean, on the question of tenure, the report is quite stark in talking about how there should be no exceptions to the point of tenure. And it's interesting when you look at the OPCW, which has, which to some extent is reconsidering whether the policy of tenure that they have in that organization is right because of the loss of expertise that you suffer through periods of tenure. And we saw a few years ago with the head of the IOM who had a 5-year term, how he left essentially halfway through because he got another job and because he knew that at some point during that tenure, he would have to start looking for a role, which would likely mean that all the best people are hardly likely to fulfill all the years of their tenure because they will start looking for roles well before the end of their term. So there are some risks around this too, I can see. Let's move on to talk about the judiciary specifically, and we've talked a bit already about the court's findings on cultural issues generally, to which the judiciary isn't immune. But there are a number of additional specific points raised in the report about the judiciary. For example, the report talks of many states parties and civil society and current and former judges, I don't know if that included you, Sylvia, identifying a lack of collegiality, including, as the report says, poisonous relations and disrespect to each other, and that contributing to a lack of continual and productive working relationship and posing a major challenge to efficient and effective judicial making. Perhaps if I go to Lis first to talk about some of these aspects of the findings on the judiciary.
Yeah, so I come at this as an outsider, and I've only spent 3 months, as you said, as visiting professional at the court. So my experience might be completely anecdotal, but what strikes me as a very helpful proposal by the panel who wrote up the report is that the judges should, in terms of deliberations, really aim for a team-based approach. So having legal officers serve the trial chamber or the pre-trial chamber rather than a legal officer per judge. And that resonates with my experience, because what you get with the system of legal officers per judge is that you have cliques. You can have cliques within the chamber. I'm not saying that necessarily happens when you have this system, but in my case, there was a chamber where there were common law versus civil law rifts, and it didn't really help to have, you know, this system of serving your judge and not your team, not your trial chamber, because very often also legal officers would come from the system, same background, would have the same legal background as the judge. So this team-based approach, I think, is a very helpful way of countering this. If this is indeed widespread throughout the court, and again, I don't know that, but Sylvia may be able to say more about it. And it's something that they've looked at, or sort of they've been inspired by the Court of Justice from the EU, who work with this referendaire system. It was mentioned already by Doug, where you've got a team led by a senior legal officer who serves, I think, a 9-year term, and basically organizes that team, manages the team, and then makes sure that that team works for the chamber. And I think that's a really good suggestion, something I hope the court will look for and maybe be inspired by. The other thing I want to say at this point is legal culture, a little bit about this, the civil law versus the common law, and ad hoc law versus ICC law. That was definitely there when I was at the court, but mind you, that's 10 years ago. I was there until 2010. I'm not sure it's still there. It might be that after so many years of working with a system that sort of fuses the different legal cultures, that we now have a proper ICC culture. But interesting that one of the interesting things I thought was to see how some judges were really pushing their own system. So there's a lot of norm entrepreneurialism going on, not just the judges, by the way, also legal officers. This has improved. I remember that Sylvia was very clear, I think, in one of her speeches, where she said that, you know, we shouldn't have ad hoc tribunal law versus ICC law. We should actually learn from the legacy of these ad hoc tribunals and enrich ICC law with that experience. And last thing about quality of judges, because that also links into this, the report, I think, recommends that they have a criminal law background, and I would agree with that, because at the end of the day, these are criminal trials, and I think the ASP should nominate from the ranks of serving criminal judges, whether it's from a national system or an international court. But there's another thing which is equally important, and that comes with this, is that they should have an open mind, that they should not just think in their own national terms. Now, that is challenging, and that, of course, requires, I think, a good induction and training program, and the willingness also on the part of judges to be trained, because not every judge wants that. So those are some reflections.
Thank you. Douglas.
Thank you. Look, I agree in broad terms with everything Lis has just said. A couple of things I'd add. I mean, there's an old adage that all lawyers are parochial, right? We're trained in our own legal system first and foremost, and that's never more true than in criminal law, because it is so intensely procedural and localized. So there is a great tendency, if we come to a first encounter with foreign or comparative law, even when we encounter as international lawyers how international law is done in other countries, we'll often go, well, that's wrong. You know, you can feel a sort of sense of affront when you first confront elements of a different way of doing law. So I think the point about needing a longer induction process for judges and a more structured one is well taken. I do also think, though, that if you know, appointment to the International Criminal Court as a judge is what it should be, a significant honour and a career capstone, then people planning long careers should be able to demonstrate when they are nominated for the court that they have put a significant amount of time and effort into learning about the court, its functions and its law. I also think that, I am a complete outsider, other than having some experience in my own national legal system of having worked as a junior legal officer early in my career to judges. The consequences of the unfortunately undoubted lack of collegiality amongst quite a number of the chambers over time is evident from the outside when you look at some of the situations where we've had trial chambers issuing multiple parallel judgments on the one issue. When we look at kind of the course of, if we're attempting to work out what the elements of command responsibility are before the court, looking over the course of the Bemba litigation, good luck working out what causation means as an element of the offence based on the judgments that have been rendered. So it is admirable that the judges have started doing things like having retreats, that there are things like judgment, writing guidelines, that there are more guardrails being put around the process of collegiality. But one of the things that goes to Elise's open mind point is a number of the judges really do need to start, and I'll be this blunt, reading the statute when it comes to how judgments are to be delivered. There is no provision in the statute for separate concurring or dissenting opinions at anything other than the appeals chamber level. The statute speaks of chambers issuing one judgment containing the reasoning of both the minority and the majority. And that speaks to a collegiate process of respectfully coming up with a common judgment that lays out the reasons for decision and any opposing minority views, not issuing them in occasionally an ad hoc mishmash with such instances as giving reasons from the bench verbally and then having different judges issue different decisions months later, that sort of thing only damages the court's reputation and legitimacy. We also need the judges we also need a one court approach to what pre-trial chambers are there to do. We have had some pre-trial chambers take the view that they are there to not merely manage, but to micromanage exercises of prosecutorial discretion. So the to and fro over the situation in Cormorus is absurd. And one of the things it speaks to is judges trying to manipulate the threshold of gravity such that they narrow the discretion of the prosecutor. Now, certainly what happened in the Mavi Marmara incident was dreadful, and there should be accountability for it. And there were no less than at least 3 different international inquiry processes into it. But it is not comparable to, say, the situation in Afghanistan. And if we set the bar of gravity as low as one incredibly regrettable maritime incident that obviously has potential elements of criminality attached to it with 8 civilian deaths and many others injured, well, then there's nothing realistically that could be excluded from the court's jurisdiction. So, we need pre-trial chambers to respect the legitimate bounds of prosecutorial discretion is another area that I have significant concerns about. And the report does call actually for a whole of court strategic approach to issues, including what will complementarity mean in practice, and an actual ongoing discussion with stakeholders, including state parties, about what that will mean. And I really do want to sound a note of caution, because there is a sort of drumbeat in the background that one thing that would improve the court is the abolition of List B judges. Now, I did a piece for the European Journal of International Law blog on this, where I looked at some of the most controversial decisions the court has given that have come in for a lot of criticism, and asked, well, how many List B judges were on the relevant chamber in each of those cases? And it was never a majority, and it was often only one. So the idea that somehow all we need is better criminal law expertise will fix every problem has to be pushed back against. Now, certainly one of the issues we've got is that List B judges appear to have been principally deployed to trial and pre-trial chambers, which is simply absurd. That is not where you put people with international law expertise. But there should certainly be a permanent presence of people with critical international law expertise at the appeals chamber level. We have a court here that deals with the very delicate interface between international criminal law and the law of armed conflict. And there is obviously the possibility of unintended consequences of, as it were, what would seem in a purely victim-oriented criminal law context, good developments of international criminal law that risk criminalizing things that there previously would have been broad consensus were lawful as military operations. So there are a number of things there. Certainly, the court is already making some positive progress, and there's much in the report to commend it. But I do think, well, I've laid out a collection of concerns, and I won't attempt to unite them. I'll give others a chance to speak.
Douglas, it sounds to me, though, like you and Elise aren't actually disagreeing on the point about List B judges, because if you say that it's absurd to put List B judges in pre-trial and trial, but that they're very valuable in the appeals chamber, then I assume you wouldn't disagree with the proposition that you need some criminal judges in the appeals chamber too. And so you're only really left with maybe 2-3 appeals chamber judges who have international law and are from List B out of 18. Is that essentially what you're saying?
Look, I don't have a complete number in mind. I wouldn't say that you should have absolutely no international law judges at the trial and pre-trial level. I mean, you're still dealing often with core and important questions of international law. I'm just saying that so there's probably no level of the court at which they should ever be a majority, but I'm not clear that there's any level of the court at which they ever have been. Certainly not in some of the decisions that have been most controversial. And when you look at the decisions that have come in for most criticism from either lawyers of a criminal law persuasion or an international law persuasion, they've seldom, like, I can't identify a single one of those benches, and maybe someone can point it out to me if I'm wrong, where there has been a majority of, as it were, judges from an academic, diplomatic, or other broad international law background.
Great, thank you, Douglas. Sylvia.
There are so many good things that have been said that I don't know where to start. And actually, maybe I can start by saying that, by answering one question by Ellie, saying, well, yes, there are still today judges trying to push for their own national systems. And the fact that, as again, I repeat, we change every 3 years 6 judges. These new 6 judges also come with their own national agenda, and the worst offenders are the ones who have most criminal law experience, because of course they are socialized and used to their own system and applying their own law. That's why I fully agree that by now it is extremely important that we make sure that judges that are elected have a very good comprehension of the system. And I think the Advisory Committee on Nominations has a good role to play there. And they have indeed asked very detailed questions to them this time. And I think this is very good. They need to come with a very good knowledge of the system, because the system now is not just a statute. You already have a lot of jurisprudence, a lot of ways of doing things. So judges should come already with this knowledge to the court. And also, again, induction and professional development throughout the tenure should also be something that could help. But another thing that could help, of course, is to have at the court more and more cohesion and more developed jurisprudence in all areas. Actually, many of the problems that have been identified by the experts have been identified by the court already. And many of the initiatives that were taken were indeed taken in order to solve some of these problems, including the role of pretrial, the transfer of cases from pretrial to trial. The manual, the Chamber's Practice Manual, is one of these initiatives intended to enhance cohesion at the court. And the experts really reinforce this idea. And actually they say the manual is a good idea, but you need to make it more prescriptive. Some of it maybe should be binding. But I think many of the things that have been done at the court already go into the direction of enhancing, first, ensuring more predictability and cohesion of jurisprudence. And that also would help with collegiality, because you would have less point of contentions every time when you deliberate in every case. So that helps. And of course, all this practice of retreats, all this also enhances the issues of collegiality. And of course, the experts mentioned this, and I fully agree, and I think Douglas also referred to this, is the need to clarify the issuance of separate concurrent opinions. This is something that needs to be clarified at each level. So, but the good thing, I would say the bad thing is that there's still a lot of problems at the court. The good thing is that many of these problems have been identified by the court already, by the experts already, and many of the good things that have been done are being now reinforced by the recommendations of the experts. Thank you.
Thank you, Sylvia. Angela, you touched on this point earlier, the issue of the process for nominating and electing judges. Now, this wasn't part of the experts' mandate, but as they put it, it was impossible to ignore the comments that they received, that in part, the result of the standard of some of the judges in particular, and the ability and experience of some of the judges who have been elected, as they put it, I'm quoting, has not marked them out as judges or jurists of the highest caliber sought by the court, and that their success is owed to horse trading rather than competence. I wondered if you could pick up this point about the role of elections and the role of states in nominating and electing judges.
Absolutely. I think it's a crucial point. And once again, I take my hat off to the experts for identifying that as something that needed to be addressed in the context of the review, because as you just said, it really has been an exercise of vote trading and political considerations, as opposed to purely voting on the basis of merit. And what's interesting about the way the experts approached it is they didn't focus so much on the election itself. Yes, they denounced the political meddling, but they focused rather on the domestic nomination procedure. Because as they put it, if all the nominees were of a very high caliber, then at the end, who you actually vote for makes less of an impact than if you have individuals who just are not qualified for the role. So that's also quite an interesting focus. So in terms of focusing on the domestic nomination procedure, their recommendations are aimed to harmonize, to streamline, and to improve the process, thereby improving the caliber of the nominees themselves. And so they had just a few suggestions that I found quite interesting. For example, insisting that the candidate turn up in person for the interview with the advisory committee on the nomination of judges, which I think is a very good point, because this is the first time the committee gets a real sense of what the candidate has to offer and who they actually are. And the same thing for insisting that the candidate turn up for the roundtables, because this is the first time that states, parties, and civil society and other stakeholders get a sense of who the candidate is. And they're quite strict on this. They say if the person doesn't turn up, then they risk disqualification. Of course, barring exceptional circumstances. And I mean, this year is just an example of how exceptional circumstances do happen. COVID-19 meant that there were no in-person interviews. It was all done via video. So I think that's quite a strong and important recommendation. Another one is requiring, rather than just encouraging, states to submit details on the nomination process. And they went so far as to say that a certificate should come with the nomination as well, and then the certificate would then describe what the nomination procedure was, and this must be signed and certified by the senior official responsible for the nomination procedure. And again, I think this is very important, because then you understand the disparity between what some states do and what others don't do for this procedure. And even though this year, in terms of the advisory committee's enlarged mandate, they were able to call for this information, only 12 out of the 20 nominating states submitted information. And in some cases, this information was very vague and not very detailed. So I think this is quite an important thing to push and to call for. Another point the experts raised was the importance of making sure the ACN, the Advisory Committee on Nomination, that their report is available earlier. And again, this was attempted this year because then it will inform states parties' decisions before the ASP. But this year it wasn't possible for various reasons, COVID being one of them. But I think this is an important recommendation so states can actually make use of the report, make full use of the report. And the last thing that I'll mention that they include is that states should be guided by the ACN's assessment. And I think this is very important because it makes no sense. Let's say the ACN rates someone as unsuitable for the job. The states should not vote for that candidate. And I think in the past, where the ACN report hasn't been as robust and as detailed as this year, this has really been pivotal, that states look at the guidance and what the assessment was of the candidate and use that for their voting procedure. But all in all, I have to say that this year, obviously, the ACN has done a much better job than in the past in terms of giving a detailed and nuanced report. So definitely think they should be commended for that. But it is clear that there's still a lot more that can be done on this, because this will really determine the quality of the people who sit on the bench at the ICC.
Great. Thank you, Angela. We've got questions coming in, and in fact, a lot of the questions are being answered just in the normal course of the comments. So I might save the remaining ones till the end, but please do keep those questions coming in. Let's move on to the issues around the Office of the Prosecutor. We've already discussed some of the points around culture. So more broadly, the report suggested that there was no clear or transparent regulatory framework governing the OTP's operations. It talked about the bullying and harassment as being particularly bad. In the OTP, it talked of a hierarchical working culture and division between senior management and other staff. It talked about the almost complete absence of women in senior positions, and then real concerns raised over the leadership of the prosecutor and deputy prosecutor. At the same time, the report questioned whether the OTP were sufficiently resourced by states to meet the high standard required of international criminal investigations. Douglas, perhaps over to you first for some reflections on the sections on the OTP.
Right, thank you. Look, I'll try and keep my comments here relatively brief, because I don't claim any particular prosecutorial background or expertise. Certainly the report highlights that the OTP is greatly understaffed at the investigatory level, and that is quite obvious. It's been a persistent complaint for some time. The report does note elsewhere, however, that all courts and justice systems operate under budgetary constraints, and expressly encourages the court as an institution to accept the legitimate role of the ASP in setting the budget. Now, it's simply a fact at present, in my view, that the Assembly of State Parties is not, particularly under the current conditions we face worldwide, going to give the court any more money than it presently has. The idea that there'll be a substantial injection of resources to remedy the problems of the OTP is not on the table. So the question then becomes, where could one find resources to do that? So secondments is one issue we've floated in the past. The report calls very strongly for the idea that the court needs all of its judges all the time, and that all appointed judges should take up their post. I wonder if that's true. I don't see a court that is sufficiently busy to justify 18 judges full-time. Others may have a different view, but you could certainly liberate quite a lot of money if not every judge was there full-time or permanently or for all of their tenure. That may or may not be viewed as a realistic prospect given the election issues we've just discussed. In terms of the actual management of the OTP, in terms of organizational design, 2 points that simply leapt out at me from the report was the report describes a bottleneck in the OTP Executive Committee, that far too many decisions are effectively deferred to ExCom, as it were, for sign-off, which results in a degree of both micromanagement and delay. And irrespective of the competence of the person holding the office of chef du cabinet, the experts list a truly extraordinary breadth of responsibilities presently held by that office, including, it would seem, input into the drafting of every document that passes to the prosecutor. I wonder if that can possibly be right, but that would appear to also be a very substantial bottleneck in the transmission of information and decisions. So those two elements, to me, seem to suggest potential bottlenecks in decision making that would be ripe for reform.
Thank you, Douglas. Elise.
Yeah, so about resources, there's one part in the report on the chapter on the prosecutor where the resources seem to be underused. The panel says, and that's the analysts. And I found that really interesting, that part, because this is really the view from an academic, again, an outsider, but it seems to me that the prosecutor has made cases bigger than they are in the past. I think certainly the first few cases, focusing on the most responsible and then selling it as if some of these warlords were running bureaucratic organizations, well, like the type of the Nazi era, and where people are irreplaceable and are just following orders automatically. And it was a way, it's a theory, to ascribe liability for crimes based, I think, on a system that doesn't really work for these particular cases. And the interesting, I went back to the strategy document of the OTP, and then they say, indeed, we focus on the most responsible, and if needed, we will build cases upwards from there. But in a number of these cases, I think that's the practice has shown that the evidence does not support the narratives of these systemic crimes of these large-scale organizations run by Lubanga or Katanga. And what we've seen in Katanga, for example, that Regulation 55 was used to basically downgrade the mode of liability and to change the legal characterization of facts. And I think a similar thing, a more recent case, is happening in Yekatom Nagasona case, where the pretrial chamber has refused to endorse a theory put forward by the prosecutor that there are these big enterprises responsible for crimes committed by groups that are not necessarily connected to the higher level people that are in the dock. So I found this quite striking, and the report refers also to this decision making. So a lot of work has gone into that. And it also causes tensions, as you see, indeed, between the pretrial chamber and the prosecutor, where you see judges saying in their judgments, however, once again, the evidence tendered by the prosecutor is general in nature. I mean, that clearly seems to express a frustration that the evidence is not adding up to the case theory. And this is where the report is important in concluding that collection of evidence should be evidence and analysis driven. So analysts are underused. They say they should be the driving force of cases, not some narrative, a case strategy, and then you look for the evidence to back it up. And I think the term facilitators was used in the report to refer to analysts, that they should not be facilitators, they should be in the driving seat. And I thought that was extraordinary, actually. So it chimes with what I think scholars have perceived of these cases. And in that sense, it's an interesting reflection maybe to compare it to the tribunal for the former Yugoslavia, where you could build up to stronger, bigger cases and to the most responsible, because you were looking into one country with different cases where people eventually a picture was emerging of a system engaged in violation of international law, whereas here you've got cases, the ICC is in charge of or has jurisdiction over cases that are sporadic incidents within one country that are not necessarily connected. So it's a different way of approaching these cases, and I think it really is time for the OTP to turn a corner. They have in a way already done that by saying, well, we're going to focus a little bit lower down the chain of command now, not only those at the top. So yeah, it was interesting how that was picked up by the report, and again, that emphasis on analysis.
Great, thank you, Lis. I'm just conscious of time, so I think we should move on to our final segment on the role of the ASP and ASP court relations. And this was another stark part of the report, which stated, and I quote, "There is widespread distrust of the ASP within all organs of the court, that states parties do not recognize that the court was created by the Rome Statute and that its role is to administer justice, not to achieve policy ends." They talk about states micromanaging, making time, and the court having to take time to produce reports, and therefore more time spent on reporting than the tasks. On the other hand, it says that states parties are frustrated with the court. And this goes back a bit to the op-ed that I cited at the outset. frustrated in not providing value for money and resisting any measures to become more effective and efficient. There were two particularly interesting recommendations, I thought. One was that states parties should do more to provide the court with greater political support against external threats. But also, in going back to the resource question, it was striking to me that the experts said the court should be resource driven. So essentially the point you made, Douglas, I think, that tailoring its activities to the budget it is given. Elise, perhaps we could hear from you first on this.
So just generally on the role of the ASP, I think the report makes the very helpful recommendation that it should support the court in legal cooperation, matters of legal cooperation. It should do more there. It obviously is because of the relationships that have been complex, that maybe not enough has been done, but I would hope that moving forward it will do that, because it's essential for the ICC for delivering on its mandate. My general feeling, however, on the ASP-ICC relationship, and here I may actually differ from what Doug was saying earlier. I think they should be quite apart, seen as separate entities, and there should not be too much crossover in terms of personnel, etc. And I would welcome a more standoffish approach on the part of the ASP. I have found that there's a sort of a sense of ownership over the court, and certainly because those on delegations, government delegations, have been instrumental in setting up the court, have negotiated the court, and in those first years have worked in the court. And maybe that was useful in the beginning, but I wonder how useful it is still. Because, you know, there is into the ICC statute, baked into it, there's a certain amount of horse trading and negotiations going on in its operation and recruitment of people. And I think it can be compounded when there's a desire of legacy preservation around negotiating the ICC statute, establishing it, etc. And I think that can actually burden the ICC in delivering on its mandate. And I would welcome a little bit more of a standoffish approach, fresh eyes, understanding the court as an organization, yes, and you can have people informing you and advising you, but I think that, to me, the healthy distance is better for the ICC.
Thank you. I mean, of course, this just goes back to the issues we were talking about in the governance model and the tensions that exist. One of the things that I think is unique about the ICC or about international criminal courts is that while states, its governance body, gives the institution money like it does to any other international organization, unlike those other international organizations, the ASP can't control the activities of the ICC, of the prosecutor, of the judiciary. And I think that is where there is a uniqueness between the ICC on the one hand and international organizations on the other. And it's a tension that I think a lot of states are still grappling with. Angela.
Thanks. It is quite a complicated issue to resolve. And I think it is difficult to expect the court to tailor its activities to the available funds, just because an investigation takes as much time and as much money as an investigation takes. So it's a difficult issue to resolve there. But what I found interesting about the other recommendations from the experts with regard to the ASP, that is things like the ASP and all the relevant stakeholders need to have a strategic vision for the next 10 years of the court. I think this is a constructive recommendation that discussions should start about what the expectations can and should be for the next 10 years of the court. And I think the ASP now has a key role in terms of implementation. Not all the recommendations are for them to implement, but I think there's a role for them to play. And we know from the Hague working groups and the New York working groups that this is something that is ongoing. Discussions are ongoing, and their ambitions to have a resolution by this year's ASP. We'll have to see how that goes. But I think it is key for the ASP to remain open and to make sure that this process of establishing a road plan for implementation should be inclusive, so that civil society, that's the court, that's the ASP, should be transparent. It's very important that everything they do is visible to all the relevant stakeholders, because these decisions will have implications, And I think also important for them to remember that protecting judicial and prosecutorial independence is paramount. I think the ASP needs to be reminded of this constantly and in different ways. And the implementation of these recommendations is one where this has to be very, very, very clear. And I think the fact that the court's principals have shown an openness and a commitment to seriously considering the recommendations and to working with the ASP where necessary is also positive, as we know from their preliminary statements on the experts' report. Of course, we'll have to wait and see, but I think that the governance structure that we discussed in the beginning could be very useful in terms of making it clear that the ASP has say and input here, but not on other issues.
Thanks, Angela. And I'd like to come to everyone after I've heard from Sylvia on this question of how to implement the recommendations. But first, Sylvia, as the president of the ICC, you obviously had a lot of interaction with the ASP. So I'd be interested to hear your views on the findings in this section.
Indeed, as a president of the court, I had a lot of interaction with the Assembly of State Parties as an organ, but also with individual states, group of states, and also those that were working in working groups and dealing with the budget, etc. So what can I say? A good dialogue is absolutely fundamental. There is this distrust in some quarters, and also, and as the experts say, some frustration that sometimes too many reports are asked from the court, and sometimes duplicating reports and overlapping demands. One of the initiatives that I really was very much favoring, I think it came from the Assembly of State Parties, but I was really endorsing and trying to push forward, was a performance indicators report. Because I thought that that would give an holistic view of what was happening at the court, how efficient or inefficient we were being, and without having so many partial briefings and reports. So I think this is something that is key, and this also, the performance indicators report also gives them a very clear view on the judicial activity, on the prosecutorial activity, without encroaching with independence. So I think those two are not incompatible at all, and I hope this may be a way of serving as a basis of a good dialogue without going into micromanagement or too many questions and many reports that they also are time consuming for the court. But I think this dialogue on the basis of good information can improve, and actually my experience was not bad. My experience was good, and and actually I also found a lot of support from the court, from the Assembly of State Parties and some states on reforms that we were trying to implement at the court. One issue that, and I had experience also as a judge, because there was this structured dialogue that was established between the court and the Assembly of State Parties on the basis of what was called at the time the lessons learned process. And I'm mentioning this because this structured dialogue could also serve as a basis of the type of dialogue you may need to have now to implement the report. And maybe I'm already going into your last question, but maybe I can say this. The report that is produced now by the expert is also a very good basis for this renewed dialogue between the court and the Assembly of State Parties. It's a very good opportunity. And I know they're already discussing a mechanism which is a little bit based or inspired by this lessons learned process in terms of having a structured dialogue, a roadmap between the two, and also a process that of course should be inclusive, not only state and court, but inclusive. All stakeholders should be involved in the discussion. Now, of course, the Assembly of State Parties the court needs the Assembly of State Parties for political support. And as president, I went through this crisis of some states withdrawing, or trying to withdraw from the Rome Statute at the time I was president. And that created huge crisis. And that also created a huge opportunity to have a good dialogue with the Assembly of State Parties. And there was a good dialogue, and the Assembly did engage in the dialogue. And the experts are right in saying, well, the court cannot engage in a political debate, but the court could take part of this dialogue on initiatives and ideas to develop in order to try to confront this challenge. So I think each one doing its own under its own mandate and roles, there is this dialogue that was necessary and that did take place. And of course, the court, sometimes for the Assembly of State Parties, it's difficult to speak in a unified voice. So you have group of states there as well. But the court also engages with states and state parties in other organs, at the General Assembly of the UN, at the Security Council, and there also the support of state parties is key, because the court needs all this support in all these relations. So I would, if I may, endorse what was said again by Lis when she said healthy distance is good. I would say, yes, it is good, it is essential, but a healthy and good dialogue on the basis of good information is also extremely important.
Thank you, Sylvia, and also for covering implementation. I mean, you talked about the working group on lessons learned and the work that you and I did, but in 7 years, there were 8 amendments. And so there is a real question, I think, about how the court and the ASP can proceed with reviewing 384 amendments, let alone implementing any of them. But perhaps we can hear from Douglas and then Lis on this question of implementation.
Right. Look, so much has been said, and I know we're very close for time, and I don't want to deprive others of the opportunity to speak. But just a couple of thoughts that might seem a little disconnected because I don't have time to put them together better. Again, I would emphasize that independence is not an end in itself, right? An purely independent court that was entirely unaccountable would simply be a collection of judicial and prosecutorial fiefdoms. So we need a court that is both independent and accountable in the same way that any justice system is constructed. And part of that will involve, as Sylvia was just saying, a healthy dialogue with the political arms of the justice system. So one of the things in terms of the way forward for me is, we can ask, who's the villain here? Is it a court that's intransigent, or is it an assembly of state parties that is micromanaging? Who's got the right end of the story? And of course, the point is both parties to the relationship are in part at fault and at part perfectly justified in their criticisms. The point is getting to that fresh, healthy dialogue, turning the page where things like a greater turnover of personnel might help, but there needs to be that renewed sense of trust between the ASP and the court, and that is going to involve, in language drawn from other fields, confidence building measures, and in part something like a greater system of secondments between governments and the court, as we've mentioned before, I think would be helpful. There's a lot more I could say, but I'm aware of time and I'd like others to have an opportunity to comment, so I'll leave it there. Thank you, Douglas.
Lis.
Okay, thank you. So I think the way forward is indeed to have a monitoring process. Obviously, I mean, we've got this report, all this work has gone into this, and it's a very useful report with very useful recommendations, and I think the KPI should be modeled on them. I would really think that this is indeed the opportunity to have that dialogue and to start talking about efficiency, effectiveness, etc. So yes, there should be, this is a new point in a way to reset that relationship and do it more professionally than it's been done in the past. And I would really encourage support for staff, so staff development, refreshing basically the machine, I think is very, very important. So just a few thoughts again, and please don't do it in the way that was done in the registry, because the revision process, which is not mentioned in this report, I think has actually done a lot of damage, but I'm sure the ICC is very aware of that.
Thank you all. Well, look, there are a few questions in the Q&A that I wanted to pick up. What I'll do, I think, is just read some of them out for you, and then go to each of the panelists to answer the ones you like, and you can avoid the ones you don't, and make any final comment that you wish. So the first question from Farhan Ahmed is around geographical representation and the weighting in favor of the global north. So how can we reset that or adjust the balance? There is a question from Alexander Skander-Garland around this assertion of the court having a dual status as an IO and a court, and whether that contradicts the appeals chamber judgment in the Jordan case on the court being defined as an international court. Should that be acknowledged by the court, or should the court have considered better the Jordan judgment on that question? Question from Judge Keith Rayner, specifically for Douglas, who should lead the strategy of the ICC? Should it be the president, the registrar, or the ASP? Mohammed Bardo, question for Sylvia and Douglas on the effectiveness of the independent oversight mechanism, your views on that. And then a couple of questions on culture from Richard Mackenzie Gray Scott and Jennifer Tridgell. Why does the court suffer from these questions or these issues around workplace culture? Is there really a sense of self-perceived aristocracy that exists within the international law profession more generally? And should there be an internal dispute resolution or mediation mechanism for judges rather than which might help with the infighting and lack of collegiality that otherwise comes out in the judgments of the court? And perhaps why is it that ICL mechanisms suffer from this public lack of collegiality? Not just the ICC, but we've seen some of that at the STL around the additional cases, as opposed to other courts like the ICJ. So let's go in the order that we started the first question. So perhaps Sylvia, if you'd like to tackle any of those and any final comments you would like to make. Sylvia, you're on mute.
Sorry. Well, I would tackle some of them, and also something that you said in reply of my reference to the lessons learned process, that you said, well, it only managed to achieve 8 amendments. Well, frankly, I think too much emphasis was put on the success of the process being in terms of amendments to the legal framework, which I always thought, well, you don't necessarily need amendments to the legal framework to amend certain things. But indeed, there was a problem, because indeed there were some amendments that were presented, and actually they were very much encouraged by states because they wanted this as part of the process. And then they didn't pass in the Assembly of State Parties because the Assembly adopts these amendments only by consensus, which is not required by the Rome Statute. So this was an impediment. And I think this needs to be revisited, because sometimes you may need some amendments to the legal framework. And the few that were adopted have been extremely important for enhancing efficiency at the court. Now, I think there are not many of the reforms that are proposed by the experts do not require legal amendments. So lots of that can be done without amendments. So that's good also. Now, on some of the questions, there was, this is always this frustration about insufficient regional representation in staff and how to solve this. Actually, and in the same question, there is this reference to the internship program. And the internship program indeed would be a way of attracting people from all over the world, except that most of it is unpaid. So lots of the good ideas that we could put forward, they require additional resources. So with if you had a paid internship program, of course, then you can bring people from the global south, from universities that do not have the resources, that they have brilliant students, but they do not have the resources to pay. But again, this is the problem of resources. But indeed, regional representation is absolutely essential for a universal court. And another one, independent oversight mechanisms. That is another, I think the mechanism is good. We try to use it quite a bit in the procedures of complaints against elected officials. But the oversight mechanism was at the time extremely under-resourced as well. So in order to be able to function more effectively, again, you need more resources. But the mechanism as an idea, it is absolutely fundamental. Mediation between judges to enhance collegiality. I would like to think about it. I think you enhance collegiality I think many of the problems of lack of collegiality is not just because they have personal problems between the judges, but basically most of these problems are based on legal disputes. So you can solve these legal disputes through more use of the manual, more guidelines to the judges, more retreats, more type of a substantive discussion in a collective way. So I would prefer that venue more than a mediation in specific cases. Although in some cases, I wouldn't say no, why not? But I think you can solve it otherwise with better working methods and more coherent jurisprudence. I will stop here so I give the opportunity to others.
Thank you. Douglas.
Thank you. I'll try and focus, I suppose, just on this question of how do we devise a perhaps 10-year strategy going forward. I think it's a very good suggestion, as others have backed also, but who would lead that process? I think, honestly, it might have to be led by someone or another collection of experts, perhaps from the outside, because if it's an ASP-driven process, it has a certain legitimacy in the eyes of state parties, but may be seen by the court as yet another stick to beat the court with. And conversely, if it's led by the registry or the presidency, it may be perceived by some on the state party side as a way of the court kind of pushing back against legitimate oversight. I do think there will be a very delicate balancing act if stakeholders are defined to include large swathes of civil society and state parties about how you balance the legitimately different objectives of states and civil society. It's going to be very difficult. The wider you make that circle of included stakeholders, the harder it's going to be to come up with a coherent strategy. But that might again speak to the need to have, as it were, some elders of both the ASP and ICC come together to lead such a process, and I'll leave it there.
Thank you very much. Lis.
Okay, so I just wanted to say something responding about the workplace culture, just saying that I think what's happened with the bullying complaints and the sexual harassment, it is reflecting a broader culture of lack of workplace satisfaction. The question was put, is this typical for the ICC? I don't think so, to be honest. I think it's, as I said, endemic in the legal culture. There's a lot of experience around that, reports and research into it. There's something about a macho culture, a lack of diversity, and it may well be that there's an added element of it being an international organization, the ICC, but it is not just the ICC. And I do not at all want to diminish what happened at the ICC by saying this, but I do think that is part of a wider problem that the law faces. One thing about the lack of collegiality, is that typical for the international criminal law institutions? I think what is challenging for these organizations is indeed, as Doug has put it, that they all come with people coming from a national law background, and especially those from criminal law background. It's the most parochial background you can have in a way, and that makes it challenging to really come to a more shared understanding of the law. And sometimes it's simple things, it's not even understanding each other. And so, yes, the ICJ, it's much easier to be collegiate and be seen as such because you all work with one and the same system. And that really is a challenge for anyone who leads an international criminal law organization, I think. So I'll leave it there. Thank you.
Thank you. Final word to you, Angela.
Thank you. I'll just pick up on the effectiveness of the IOM question. I think it's a very good question. And as Sylvia has already pointed out, there's a resource deficiency there, financial and also in terms of human resources, but also a structural deficiency. And this is something the experts also highlight, is that they say the head of the IOM is a P5, and the difficulty in then investigating or looking into people who outrank you, of course, is implicit in that structural deficiency. So there are definitely some changes there that need to take place. And one of the experts' recommendation is, for example, forming a judicial audit committee so that the elected officials and the principals of the court can also be held accountable through mechanisms of that nature, which will, I think, alleviate some of the burden that the IOM has. So definitely some work that can be done there. And very quickly on geographical representation, very important issue, and the court needs to ensure diversity and to encourage people from other regions to join the court, and even consider non-state party people, because how else do you encourage universal ratification of the Rome Statute if you're not opening it to non-state party people? But of course, this is where politics and geographical representation, where the rubber hits the road, so to speak, because obviously states parties want their people in international institutions. So it's a complicated issue, but I'll leave it there.
Thank you. Well, we could have gone on for another hour and a half, I think, particularly because we didn't answer two of the questions that came in around the saga of the election of the prosecutor, which we'll have to hold off for another time. But this has just been the start of a conversation, I think, on this report. So thank you to all our panelists. Thank you, Sylvia, for getting up at 5 a.m. Thank you, Douglas, for staying up till almost midnight. Thank you, Elise. Thank you, Angela. Thank you to the audience for all the questions. This event will be online shortly, so please do tell others about it. Please watch it again. Thank you very much to Bickel for hosting us. Have a good day, everyone. Thank you.
Thank you, everyone.
Thank you, everyone.
Bye-bye. Take care.